Welcome back. For anyone just joining us, my name is Bryden DeWitt. I am a partner in our employee benefits section. I focus my practice on all areas of employee benefits law, including qualified retirement plans, health and welfare benefit plans, ERISA fiduciary duties, and benefit issues arising in mergers and acquisitions. Now I'd like to welcome Edward Shank and Yorgos Kaliopoulos. Edward Shank is a partner in our labor, employment, and immigration section and based out of our Raleigh office. He helps companies resolve complex workforce issues and disputes with business competitors. He represents clients across the United States in a variety of all aspects of state and federal law. Working within the firm's IP, corporate cybersecurity, employee benefits, and healthcare teams, Edwards' clients include domestic and foreign companies in the technology, life sciences, pharmaceutical, digital marketing, search engine optimization, healthcare, performance textiles, restaurant and hospitality, construction, and manufacturing industries. Yorgos Kaliopoulos is a senior associate with our labor, employment, and immigration section based in our Virginia Beach office. He advises clients on a broad range of labor and employment relations matters, including Title VII, age discrimination, fair labor standards, family and medical leave, the WARN Act, wrongful discharge, and restrictive covenants. George helps develop and manage company policies, employment practices, employment handbooks, terminations and reduction in force plans, and executive employment agreements. Edward, I'll turn to you to kick us off.
Thank you so much, Bryden. I'm glad to be joined by Yorgos today and looking forward to presenting on this topic, threading the needle, and that's exactly what we're going to try to do today and discuss sort of the intersection of complex issues with the ADA, the FMLA, and state workers' compensation laws. So if we would begin, I think, with I'd like to pose test questions at the start of the presentation. And so we're going to start with a day in the life of my sort of the typical Friday afternoon phone call. And for employment lawyers and human resource professionals, litigation attorneys, nothing, not always great happens after about 2 or 3 o'clock on a Friday. Most of the time, my clients aren't calling me to tell me what a wonderful week they had with their workforce, how great everyone was. There were no stupid human tricks to report, and just wanted to let me know all was well going into the weekend. No, usually it's some form of a signal flare or a little bit of a fire alarm. And the hypotheticals and the examples that I'll pose today, at least from my experience, these are real world, real life, sort of ripped from the headlines from what I see on a day-to-day working with clients. But to jump right in, the phone rings and I'm hearing from could be someone in management, human resources. They've got an injured employee, hurt their back some time ago while performing a manual labor type job. This person's been out of work continuously for several months, not able to perform any work, and has fallen into the workers' compensation system where they're receiving some form of benefits on a weekly basis and getting medical treatment. The employee did just receive some medical updates and was released to return to work, but subject to medical restrictions, and those included a 30-pound lifting restriction, the need to take some occasional breaks, and then at times to get help from a coworker repositioning and moving heavier, bulky objects. There's some suggestion that some anticipation the restrictions will be lifted in time. Next slide. Now, the employer tells me, Edward, I can't have a worker who can't do the whole job. Even if I could accommodate this 30-pound lifting restriction, sitting breaks and a request for a helper, these are really going to cause morale problems. And his supervisor's telling me that this guy has already cost the company enough money. And I think that's in clear reference to the workers' compensation claim. Some other facts: this employee doesn't have any more paid time off. They've used it all up. Now, none of this leave was designated under the Family Medical Leave Act, FMLA, as FMLA leave. So they've been out of work a couple of months now. Now, the workers' compensation doctor has said, A full recovery may be a few 3 to 4 months away. And this employee is asking the client, hey, are you going to accommodate my work restrictions? And if not, are you going to hold my job open for this 3 to 6 or 3 to 4 months? All right, let's move on. Slight plot twist before we get to the end. We find out that there is, however, an open shipping clerk position. Um, this is not really a manual labor type job, mostly seated work at a computer terminal. Our employee has never used this shipping software, but he knows everything about shipping logistics for the company. He'd been there like 20 years. It pays the same as his current role, but the employer tells me that to everyone else, this is going to look like a promotion. Thank you. All right, we'll move on. So, what are some of the issues that anyone on the in the presentation here has recognized or heard of, or where does our mind go when we've got an employee who's out on a medical leave? It could, in this case, it is workers' compensation. What's going on here? These restrictions, we've heard perhaps the phrase reasonable accommodation under the Americans with Disabilities Act, the ADA. What are the functions of the job that he's restricted from? Are they essential to the job? Are they marginal? What, if any, burden would be placed on the employer by having to accommodate these restrictions? Hopefully, for some of us out there, we're starting to hear some buzzwords. And with respect to his leave of absence, is this employee potentially entitled to additional leave, whether that's under the ADA, and maybe what effect does the employer's failure to designate his leave under the FMLA, what effect might that have? And, what were we talking about this potential shipping clerk job for? Is it possible that the law could require the employer to transfer this employee into a new job, even though he'd never worked it and wasn't working it while he was injured? So those are the sort of buzzwords, topics, issues. We want you to think about the hypothetical. Don't get nervous. There's no immediate test question right now. And for those of us that this is a 101 course for, we'll help you with some remedial suggestions or foundational training along the way. But with that, I think we'll go on to the next slide. And I'm going to turn it over to George, because George is clearly the brains of the operation. And he's going to educate us on some of the background of these laws that will help guide our answers to this hypothetical and other questions. Take it away, Yorgos.
Thank you, sir. Edward uses the term brains lightly, but I appreciate the compliment. So you just heard a not uncommon scenario that employers encounter that could trigger a number of laws. You've got the ADA, you've got the FMLA, and then there are, of course, state counterparts in most of the states around the country. So talking about the ADA, what is it? Well, it prohibits two main things: discrimination and retaliation for people with protected disabilities. And we'll get to that part in the next slide. But it prohibits discrimination against people with disabilities in employment, transportation, and public accommodation. And that includes communications and access. And let me explain. So private employers, some of them, could be subject, if you have guests, in addition to be subject to the ADA for your private employees, i.e. providing a reasonable accommodation, if you have customers coming onto your premises, you could be subject to an ADA violation if, let's say, you don't have wheelchair access. Or what we've seen with some hotel customers is that their website was not ADA compliant, according to plaintiffs' attorneys that I've encountered, because blind individuals cannot book hotel rooms because there was no software or the website was not designed in a way that allowed the individual who could not see to use their software to have the website get read to them. And more importantly, they could not book the hotel room online without being to see. Now, our client argued there was a phone number on there that they could have called. But the position with the regulatory agency that was involved said, well, he should be able to book the room the same way as someone who could see. Now, is that an undue burden? Not according to the people that were suing our client, and not according to the regulatory agency. It protects qualified individuals with disabilities from discrimination in employment practices, and that includes applicants, not just existing employees. It's in recruitment, hiring, discipline, and firing, pay and employee benefits, training, promotion, and advancement opportunities, and leaves of absence. Further, the ADA protects people from associational discrimination. So basically, if you, let's say your spouse or your child is disabled and you feel that someone is discriminating against you in your employment, or you're receiving an adverse employment action because you have someone that is disabled, or they think that you probably couldn't fulfill the requirements of the promotion because you have to care for your disabled family member, that potentially would entitle to that employee to a claim. Next slide, please. So who is protected? It's a qualified individual is someone who has a physical or mental impairment that substantially limits a major life activity. Importantly, major life activity is defined very broadly. Caring for oneself, performing manual tasks, seeing, as I touched on earlier, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, or working. And I think concentrating and thinking are important in the sense that if you're dealing with a more white collar type job or a desk job, and that person raises a mental impairment that causes them to at least have bouts of time in which they are unable to perform their job, they are arguably protected under the ADA. It doesn't just work in the sense of your typical blue collar position, such as the individual in the scenario that Edward gave earlier. It also protects people who have a record of a disability, and that usually comes up in the discrimination context. I'll give you an example. If somebody was out on FMLA leave and they had come back, but someone, in addition, and they received, let's say within a month or two of coming back from their FMLA leave, a reduction in their pay or benefits, or a reduction in their job title or status, they potentially have a claim for having a record of a disability. Next slide, please. Now, importantly, the person has to, in order to be qualified, the person still has to be able to meet the basic requirements of the job. And that includes education, experience, skills, licenses, and they have to be able to perform the essential functions, importantly, the essential functions, not necessarily all of them, with or without a reasonable accommodation. So you think applicant, and you're interviewing a job applicant, and they disclose to you before they're performing the position that they don't have an associate's degree, and you require at least an associate's degree for everybody across the board. Well, you would have a legitimate business decision of rebutting a presumption that you discriminated against them because they disclosed to you that they were wheelchair bound, and shortly after disclosing that to you, you didn't give them the job.
George, I'll jump right in real quick with an example.
Please do.
Something that's come up, in fact, very recently, and it goes to the qualified individual. And this is a pretty nuanced issue, so a little bit beyond the ADA 101. But I recently had a case where a large institutional healthcare provider, hospital system, had an employee who applied for a custodial position, was seemed qualified, checked out, began performing the job, and within a matter of days almost started reporting that back pain was causing a problem, performing some basic mopping and floor waxing duties that were clearly within the job description. And so we started exploring that, and let it suffice to say, the skeptic in me and the client quickly realized, because the employee almost immediately, with real precision, identified a couple of other open jobs within the hospital system that were outside of the custodial department and was specifically requesting these. And there was evidence to suggest that this was a case of an employee, while who may have had a back injury or a back condition, had deliberately gotten in to the employer's network as an employee and wanted to use this as an opportunity to hopscotch into what she perceived as a better role. Well, that case was defended on the grounds that she was not qualified to begin with, because at the outset of the job, she couldn't perform the essential functions, and there wasn't a reasonable accommodation to not mopping or not waxing floors. So it was on a foundational level, she didn't meet the qualified definition. I thought that was an interesting approach that the client and I identified, and it relevant to this definition. But thank you, George.
Oh, thank you for that. And I think to piggyback off of that, the remote work, the nature of remote work that's especially evolved after COVID has created so many scenarios that employers are struggling with. And I'll give you an example. I had a case recently. Employee had a mental health issues that were triggered by some recent events, specifically PTSD, and the employee was alleging she could not work hybrid anymore. She had to be full-time at home. And well, in the job description, it was a clerical role, and the job description said part of your job is to check the mail. So the employer would say, all right, to accommodate you, just come in once a week to check the mail. Well, I had a feeling that the employee, something was telling me that the employee was no longer in Virginia. So we pulled the employee's audit logs, and turns out she appeared to now be living in Florida. So, it's always good to just kind of look behind the scenes, see what might be there. And some employees could very well have a legitimate need to be home full time. But, just as important was the fact that this employee had to be managed. This was a teamwork environment. I've had EEOC investigators push back and say, look, you can work in a team environment. You've got Teams calls, you've got video calls. It's just like being in person. And, of course, some employers agree to disagree on that.
I think, George, we can all agree that remote work is full remote work is a gift of the pandemic that continues to keep on giving for our clients. But great example.
Exactly. And for disputes. Let's go ahead and pull up that poll. Which one of the following statements is most correct?
Most correct.
First one, employees must specifically state they need a quote unquote reasonable accommodation under the ADA to assert their rights. Employers who reject employee accommodation requests while also proposing alternate accommodations likely violate the ADA. Or third, employers should have interactive discussions when they have reasonable notice of an employee's potential disability issues. 30 seconds remaining.
Right. Choose the most correct, which suggests that maybe more than one could be correct, although I don't know. Maybe I shouldn't go out too far, and the attorney probably shouldn't admit to his audience that he wasn't the best standardized test taker. Well, we certainly don't want to give away a freebie, but we can see what's going on here. Oh, the interactive discussion seems to be polling well. Is it a trick? Did we throw a trick question in early?
I think that's the safest bet.
I agree. I was trying to shift the numbers.
Yeah, you want to engage in that interactive process, and forgive me if it ends up showing up on another slide, but it's important to show a record, a documented record of having discussions with the employee. Even if you prefer to have a bunch of phone calls or in-person meetings, it's always great to follow up and put it in the file.
That's right. And a couple of other takeaways from that. Um, Employees are not required to use so-called magic words. They don't have to say reasonable accommodation. They don't have to specify the ADA. The other point to that, I believe one of the answers was that an employer violates the ADA if they reject the employee's requested accommodation and propose an alternative. And that's not the case. Employers are free to propose alternative when to do so is reasonable, and we'll talk about that later. All right, very good. Well, I think we'll move on then. Okay, more on the ADA. Let's get a little bit more into the nuts and bolts. What are the employer's obligations? First and foremost, reasonable accommodation. And at a broad, high level, this includes any change or adjustment to the job or the work environment that an employee or applicant will help them perform those essential job functions or to get access to sort of the benefits and privileges of employment. Just so long as they're on basically the same playing field as other non-disabled workers. So common examples, I think we start with the most obvious and perhaps more antiquated, but still very relevant. So acquiring or modifying the physical space, new devices, physical or ergonomic adjustments to workstations. Time was when you had to submit a doctor's note and other information to get a standing or elevated desk in an office and be, quote, disabled. A lot of employers make that, more of a perk, or in some cases a soft documentation issue. But that's, part of what we're talking about. And again, dating myself, it would be things like physical access to buildings, things that you can touch, feel, etc. A job restructuring. Now, that's an interesting one, and we could spend an hour on that topic alone, but it goes to sort of the modifications potentially of duties within a job. And that triggers this essential functions versus marginal functions. You can't take essential functions away, but if it's a marginal function that's kind of outside on the periphery, they don't do it much, and it's not that significant, can that be eliminated? Then you've got things like telecommuting, flexible or modified schedules. Those are all within the gambit of potentially reasonable or reallocation of non-essential duties. And then transfer and even reassignment to an open position. So right there, we've listed a few things that may implicate, if we hearken back to our hypothetical, starting to connect the dots. Not at all suggesting that any of these are automatically required. It's very fact specific, but there's a star on reassignment and transfer because that is one that, many courts call the accommodation of last resort. But it can certainly be reasonable, and so many clients, well-informed clients, don't automatically think of that or entirely ignore it. Thank you. We'll move on to the next one. So if you've got reasonable accommodation on the one hand being the obligation of the employer to evaluate, on the other hand, you've got undue burden or undue hardship, and that no employer is obligated to implement an accommodation that would pose an undue hardship on the employer's business, its workforce, et cetera. Now, let me say that is probably, and as a caveat, we are privileged to work with wonderful clients who I genuinely believe everyone is striving to do the right thing. The problems arise with the mousetraps and the nuances and getting caught in the spider webs of some of these laws and all of their overlapping obligations. But I will say that one of the commonly thrown up defenses is up, Edward, we can't do that. Undue hardship, undue hardship. It would cost too much money. It's oftentimes that, too many people would want it. It would be a mess. Well, undue hardship it's frankly a very high burden to prove under the law. You're talking about extensive, unreasonable, substantially disruptive, and things that fundamentally alter the nature of our operation of a business. And these factors are what the EEOC and what the courts are going to look at when they're weighing an employer's argument about undue burden or undue hardship. It's hard for our Fortune 1000, Fortune 500 clients to, who are typically not in the debating the minute costs of certain things, but it's really hard for large institutional employers to claim cost is the sole reason why they can't do something. And I'm as conscientious of our clients' bottom line as anyone. But cost alone, if that's the best argument, it better be significant, and you better hide the Italian and German sports cars in the parking lot when the EEOC investigator comes to do interviews. Reallocating of essential functions is an undue hardship generally, and requiring other employees to do the work of the disabled worker. The old adage was, it's never a reasonable accommodation to make two employees do the job of one. Now, times changed a little bit. That adage isn't airtight, but it's a decent rule of thumb. Another defense to accommodating employee is if that employee poses a direct threat to their own safety or the health and safety of others. And that means a significant risk of substantial harm. I have well-intentioned clients, many in general industry, construction, the trades, the various subs who rightfully have reasonable concerns about worker safety. And, it becomes a challenge when you've got medical clearance and medical opinion and an employee who says they can do the job, and employers supplanting their own judgment for who is safe. But I know that direct threat, like undue hardship, are very difficult burdens to pass sometimes. Thank you. Next slide. All right. Yorgos touched on this earlier. The interactive process. It's another one of your $5 words here, phrases. Very important. It describes this formal and informal back and forth, this dance between employer and employee working through an accommodation request. And there are, a few phases of it and a few components of it. Generally speaking, the employee is expected to initiate the discussion, but we're lawyers, so we have to say, but not always. Sometimes if the issue is so obvious and the employer has notice of it or should be on notice of a potential disability, maybe that's something that you need to think about. The use of documentation, Yorgos described, it's fine to have conversations, but the lawyers will tell you if it's not in writing, it didn't happen. So follow up and confirmation, if nothing more, to make sure that both parties are on the same page about an accommodation that was proposed and what the initial response was. And I always say, when in doubt, punt. Part of this interactive dialogue gives an employer the ability to take the information in and then go back to the office and think about it, pick up the phone a friend in someone like Yorgos or myself, and talk it through. You don't have to call the ball and strike right there in the conversation. Again, no magic words are required. And if you see something and you know that something's going on in terms of potential disability creating a problem, best practice is for an employer to initiate a discussion. But how you do that, what you say, and how you do it, very delicate and needs to be handled appropriately under the law. Next slide.
All right. So we talked about the ADA, which could involve some leave, but often involves workplace accommodations. Now we're talking about the Family Medical Leave Act, um, who is subject to the Family Medical Leave Act. We'll talk about that on the next slide, but this deals with job protected leave. Now, under the FMLA, it's not paid, but you can require employees to use PTO at the outset, exhaust it, and then take the rest of it as unpaid FMLA leave. Now, what does that cover? It covers job protected leave to take care of your own serious health condition or because you have to take care of a family member's serious health condition. The FMLA regulations and statute, they lay out circumstances, not all of them, but several circumstances that could trigger a qualifying event for which you would be entitled to FMLA leave, overnight stays in hospitals or other medical care facilities, conditions resulting in incapacity of more than 3 days and require ongoing medical treatment, multiple follow-ups or single employment. Just getting the flu for a few days does not entitle you FMLA leave. Now, what about long COVID? I'm sure your medical provider would provide some substantiation that could be FMLA qualifying leave. Chronic conditions that require treatment of at least twice a year. Pregnancy, including prenatal care. So again, talking about pregnancy, employees such as the mother or birthing parent would get 12 weeks, and the non-birthing parent would get what's called bonding leave, and that's 6 weeks. And just to clarify, the parent that gives birth would get 6 weeks to recover from the childbirth, and then 6 weeks of bonding leave for a total of 12 weeks. Next slide, please.
All right. So a quick overview here, and I'm going to go through these a little quickly. The content information is in your slides. We'll catch up to keep on pace, but you have applicable to covered employees, and those are employees who work for an employer who employs 50 or more within a certain geographic radius, and then they've accumulated 1,250 hours of service in 12 months. Working through even who can be covered can be a challenging math problem and a diagram, drawing diagram. So there are multiple ways to count employees. There's multiple ways to count hours of service. Just generally know that you get 12 weeks in the 12 months. Of course, block leave for periods of days or weeks is allowed, and also the bane of every human resource professional's existence, intermittent leave for partial days, unplanned medical absences for intermittent leave. There is a web of potential issues within intermittent leave in and of itself. But know also that depending on employer's policy, FMLA can often run concurrently, meaning the employee be required to use paid time off, and often designated concurrently with any workers' compensation leave. Next slide. Communication with employees under the FMLA. Again, you've got multiple ways to calculate it and determining the calendar year and when actually was the first day of leave. A denial of eligibility. I would say that rarely is eligibility, which is sort of a threshold determination issue, rarely is that denied for lack of a serious health condition. Just like with the definition of disability under the ADA, serious health condition can get fairly broad. The rules or the regulations are a little more clear on what qualifies under the FMLA. One of the issues that we see commonly questioned or labored over is tracking the deadlines and time for the submission of FMLA paperwork, the turnaround of it, the medical certification we'll talk about later. But what I would say is having a very good understanding of what the FMLA requires under the law and what your own policies say about FMLA leave and how it's designated, and making sure that your policies are current, that you're following them, and that those policies are, of course, compliant with the law. Thank you. Next slide. All right. And we've got our polling question number 2. So everybody's alert now and tuned in to make sure they're going to answer our polling question. Employers can lawfully implement maximum leave policies that result in termination when employees remain out of work after exhausting 12 weeks of FMLA. True or false? Okay, so this question is asking a maximum leave policy. I've seen this many times. Policy says your job, unless notified otherwise, is subject to automatic separation after 12 weeks of FMLA if you have not fully returned to work. Is that lawful or not under the FMLA? A maximum leave or automatic separation policy. Hey, you've exhausted your 12 weeks. You got what the law gives you, what the FMLA gives you. We can administratively terminate you, frankly, without any notice. True or false? That's legal. All right. Okay, and a little bit closer call. Yes, false is the correct answer. And to be clear, a little bit tricky, but showing how we are threading a needle here. Under the FMLA, if you've exhausted your leave, you've exhausted your leave. But the question also implicates additional leave under other laws. And we may have touched on, I know we'll talk about it later, additional job protected leave under the ADA as a reasonable accommodation, and outside and in addition to the FMLA. That issue is one that I have had the most experience or most, I would say, discussion with employers over the past few years. The courts have spoke on the issue. It's fairly well settled. So beware of automatic termination policies or maximum leave policies. Might be okay under the FMLA, but watch out under the ADA. We'll shift to workers' compensation. We won't spend a lot of time on workers' comp just because workers' compensation laws are entirely creatures of individual state laws. Unlike the ADA and the FMLA, which is entirely federal, sure, many states have their own analogs or similar laws, but those are federal laws that apply across the 50 states. Yes, there's some interpretive differences under the different courts, but generally we're talking about a uniform system. Under state workers' compensation law, we're talking about a 50-state patchwork. So very state specific. However, the takeaways are, employees who are injured on the job in the course and scope of employment generally are going to qualify for some form of weekly disability benefit and leave of absence pursuant to company policies and medical treatment. But the real takeaway is bringing workers' comp employees into the fold of the discussion of the overlapping FMLA laws and ADA. Workers' compensation employees, once they're in that system, they're not on an island with no other rights. And the ADA and FMLA absolutely can apply to them. So many times historically, we've put them in their own little special corner of the company and treated them very differently, and that can result in some big trouble. Next slide. Okay, enforcement agencies. And Yorgos, I apologize if I went over one for you, but I'll run through this one and then maybe flip it back to you, okay?
Sounds good.
So, what we need to know about this, just a little reminder about who are the watchdogs, who's enforcing and investigating these beyond your friendly neighborhood plaintiff's attorney. The ADA is like Title VII and others, enforced and investigated for compliance by the Equal Employment Opportunity Commission, the EEOC. The FMLA falls under the United States Department of Labor, their wage and hour division. And then workers' compensation, again, you've got this patchwork of state agencies, state boards who hear these claims. I'm interested to hear a couple of things from George about these agencies, but what I would say is it's just good to know that if an employee believes that they have a claim for retaliation or discrimination under the ADA, their right includes and requires to file a charge, a complaint of discrimination with the Equal Employment Opportunity Commission, and that will be investigated, and an employer will need to provide a response. In most cases, we could talk for hours on that process, but just know that the ADA is investigated and reviewed by the EEOC, whatever your experience may have been with them. Same process sort of for dealing with the FMLA claims, just the United States Department of Labor who does that. I know that we work very closely with our local and regional EEOC offices and Department of Labor offices to build rapport with their investigators to the extent we can, because we're repeat faces over there. So making sure that our clients are off on the right foot is important. George, any inside baseball from you on experience with local offices in Virginia or elsewhere?
So I deal mostly with the investigators here local to Hampton Roads, and I would say, especially once you build a rapport with them, and you're honest in your representations, they tend to be fair from what I've seen. Where I've seen things go off the rails is where the employer, even with good facts, they come off as not being transparent to the investigators here, and then they will almost always send a request for information. Then higher up in I would say their priority of cases is when you have more than one employee alleging discrimination, like disability discrimination for the same employer. They seem to take a lot of interest in those cases. But I agree with you that building rapport with them is very important.
All right. Well, Yorgos, I'll let you take us through the next couple.
All right, next slide, please. So medical certifications tend to be a hot button issue, especially in the ADA cases that I have. FMLA, if you have more than 50 employees, your process should be, or should have gotten to the point where it's a bit formulaic. You've got your form, you give the form to the employee, let them fill it out, let them take it to their medical provider. Of course, when the need for leave is obvious, you may have to skip that. Avoid the Genetic Information and Non-Discrimination Act information, genetic information, history of, did your mother or father have a history of cancer, diabetes, or whatever it is. Please avoid those questions. I fortunately don't think I've seen a GINA case. You typically need certifications when they leave for FMLA, such as, if the need is not obvious, someone is getting a surgery, they're making a representation, then you can absolutely get medical documentation substantiating that. But for manual labor, for example, you would need a medical certification from the healthcare provider saying that the employee is fit to return. Now, what happens when the doctor says my patient is ready to come back to work full duty, and just based on your own observation, you see that that's clearly not the case? Do you have to listen to the doctor? Do you have to take the medical certification as gospel? And in my opinion, depending on the circumstance, the answer could be no. And I'll give you an example. I had a client. The employee was a line cook in a restaurant, and she unfortunately suffered from very violent seizures. And the employee had one, went to the doctor, two, then a third. would get a certification, say she could come back, then she would have a fourth, get the medical certification, say she would come back, then she had a sixth. And the doctor, we asked, do you need leave? Do you need continuous leave? And we try to have that interactive discussion under the ADA because she was not eligible for FMLA. And the doctor again said she's ready to come back to work starting Monday. And the client, unfortunately, had to terminate her. And in her defense, in her deposition, well, we used the direct threat defense of she was not only a danger to herself, but a danger to her coworkers because she would fall on the floor. There was hot oil around, there were sharp objects. And to her credit, I don't think she told the truth in her deposition. I don't think she realized the nature of her seizures until she was shown a video and was very candid and said and agreed that she was not only a direct threat to her own safety, but the safety of her coworkers. And it was a very sad situation, but that's an example of where the doctor can be wrong because the doctor is not with them all the time. Next slide, please.
All right, and you're talking about, and actually George has covered this really well and sort of balancing and going back and forth between the FMLA and ADA when it comes to medical certifications. You see the content there, and I'd encourage everybody to go back and look at it. I would say that my experience is that the FMLA's medical cert process is really you have the guidelines and the regulations and the Department of Labor's website. It's pretty clear there. The ADA can be more of a Wild West because it's not driven by regulation per se. So, job return to work certifications, the specifics on what you can do and when you can do it beyond some general rules aren't as clear. Can we go to the next, please? Workers' compensation, again, to go through this, I would say the good news about workers' comp and medical certification, very much driven by the regulations and the state workers' compensation laws. And we know, unless an employer is self-insured, that oftentimes, the majority of the time, this is going to be handled by a workers' compensation insurance provider and an adjuster who's expertly familiar with navigating all of the medical certification, independent medical evaluations, et cetera. They're going to be a good first line resource that's going to take that off your hands. Next slide, please. I tell you what, Yorgos, to really get caught up, we could go ahead and flash forward to maybe 56 and get into some of the more exciting case law discussions if anybody's excited about that. And just know that there's a web of regulations and rules on managing benefits for employees under your different laws. And, once you get one employee protected under the ADA and the FMLA, and if they have workers' comp, you have to evaluate what they may be entitled to under each law. So, Yorgos, if you're okay, I think we'll bring up the next polling question and fast forward to get into some of the case specifics.
I agree. I think we covered a lot of this in our discussion earlier anyway.
Yep. All right. You want to give them the question, Yorgos?
The ADA never requires an employer to transfer an employee into a new/different position as a reasonable accommodation because job transfers are always considered unreasonable. True or false?
We may have given away some hints on this one along the way. Let's see. Let's
I
see
think
if our
never is a
audience was,
strong word.
especially when you're talking. Well, it depends on what side of the case you're on. If you're the lawyer, sometimes you hear never, and sometimes you don't.
As a employer side lawyers, I like to use the word never. That might not be right though, in the eyes of the judge.
We getting any feedback there? All right.
False. People are learning on this. I'm very happy.
Oh, and I'm so glad we enabled the feature so that the panelists can see who voted true. No, I'm kidding.
I was gonna say, not sure if we should have done that.
No, just kidding. All right. Let's flash forward to 50. Yeah, here we go. So I'll kick this one off. Slide 57. We're talking about exclusionary light duty programs. And now we fast forwarded just to orient everybody and set the table briefly for the last few minutes. These are some sort of commonly raised or litigated issues, things that we've seen develop in the past, and we've got some case law on it. But I'll tell you what, the issues still come up regularly. So again, sort of ripped from the headline, and even though stuff you see from 2015, 2017, these are still very relevant issues, and I get calls on them frequently. So exclusionary light duty program. They can potentially violate the ADA and the Pregnancy Discrimination Act, according to the Supreme Court and the EEOC. And when I talk about exclusionary light duty programs, what we're talking about, these are a light duty that is offered only to one class of disabled workers, say workers' compensation employees. Remember, I mentioned earlier about the dangers of putting them in a bucket and treating them very differently, because in this now sort of famous case, employer only allowed light duty to non-pregnant workers' compensation claimants. They said, "I'm sorry, we offer light duty, but you're not a workers' compensation employee. Pregnancy, that we're really not able to accommodate light duty." Well, exclusionary light duty policies were ultimately found to be discriminatory in this particular Young v. UPS case. So I still have employers who mention we don't offer light duty. And you got to be real careful of that, or careful in saying we don't offer light duty to people outside of workers' compensation. It's an issue to flag. Same result from an EEOC filed lawsuit. Again, evidence showing that light duty was routinely provided to other classes of employees. George, you want to take the next one?
Our next slide, please. Maximum leave requirements or no fault attendance policies. So we kind of touched on that earlier. Are you allowed to institute a policy where employees with disabilities get no additional leave after the 12 weeks under the FMLA? Well, the answer is no, because you would likely be subject to the ADA or perhaps a state counterpart where additional leave could be considered a reasonable accommodation under those laws. Of course, they take into account the size of the business, cost on the business, burden on the business, etc. But having a rigid maximum leave policy is almost always problematic because it shows that you will not engage in the interactive process to determine if you can even accommodate that employee past 12 weeks. What if they just need another week? What if they just need a few days? Next slide, please.
Yeah.
So, Edward, you want to take this one?
No, I think we're just really talking about a little more of the same there on that. Well, that's 100% healed policy. That's right. That's another good one. I've had many cases that start from the position where, I'm sorry, we can't accommodate that. You can't come back until you're 100% healed. And that ignores the ADA interactive process. And the key is having the conversation, understanding what the limitations are, and making sure that we're thoughtfully considering all of those cascading issues under workers' comp and ADA, and if applicable, the FMLA. Tip and trick on direct threat. It's as hard to show, I believe, as undue hardship. You know, an employer just isn't going to be able to supplant their judgment, their perception of a threat. And so, how do you do it? You know, I mean, I've had cases where we've had to have statements from coworker witnesses, you know, about seeing an employee very shaky on a ladder, unable to carry near miss incidents with slips and trips. And that's a whole web of other issues to consider. You know, how do you prove it, and what can you ask a coworker to observe and to write down? It can be really tricky in getting into building a case for direct threat, and while also maintaining privacy and confidentiality rights. So just it's not a flag that can be thrown up lightly. Next slide.
So I think you kind of touched on this one, Edward. This is the UPS case where the employee asked to be
Different UPS case though, right? Yeah, this was a 2023 case and a very important one to touch on before we leave on reassignments.
Yeah, so in this case, the UPS driver was injured, and he asked to be assigned to a smaller truck with a softer suspension or reassignment to an inside job. And UPS was able to demonstrate that they engaged in the interactive process. They did everything they were supposed to as far as the court was concerned, as in having a discussion with the employee. And they said, look, that's an undue burden on us because the smaller truck needs to make more trips, and they could demonstrate with spreadsheets and figures and tangible evidence that that was more expensive for UPS. And they offered him instead unpaid leave. So he sued and said they should have granted me the unpaid leave. Well, he lost. It was affirmed by the Fourth Circuit, and the Fourth Circuit, went through in its analysis how you don't have to take the employee's suggestion. It's a reasonable accommodation. There's some deference given to the employer as to what's an undue burden, what's not. Next slide, please.
All right. And important takeaways from that Hannah case. The Supreme Court declined to hear it. So the Fourth Circuit, where we sit in North Carolina, Virginia, had the last word on that. Reassignment was not required in that case because the employee didn't even identify a position that he'd be qualified for. Huge fact. And job transfer, undue burden to a smaller truck because they showed the math. That still rings true from my third grade arithmetic teacher. Show your work. They had the data to show the burden, which is crucial. So as we conclude here, I think three basic things. Anytime you've got a leave of absence that relates to an employee's medical issue, I think we should start thinking, does the FMLA and does the ADA apply? Workers' compensation, we're probably going to know that. That's just one other thing to add in the mix, but be thinking about it. Stay constantly on top of it. Manage the information and the circumstances to make sure you've got, relatively current info from the employee about their situation. Always look at your policies to see. Yep. Always
it
check.
Looks like we're out of time.
Oh, here we are. So you've got the content there.
Sorry about that. Didn't mean to cut you off. Trying to keep everybody on schedule. If you asked a question we didn't get to today, we will reach out after the program to follow up with you directly. Thank you for joining us. You are now headed into a break.